Good morning, everybody joining us from Europe. Good afternoon, everybody joining from Southeast Asia. Welcome to our webinar today with the topic Vietnam New Competition Law, What Business Should Know. The webinar is brought to you by a project funded by European Union with the support of our external expert, Mr. Tuấn, Managing Partner of VCI Legal, member of Eurocharm Legal Sector Committee, and Ms. Nga, our external IP expert. She is also chairwoman of Eurocharm Vietnam Legal Sector Committee. My name is Xuân Nguyễn, Project Officer of Southeast Asia IPR SME Head Desk, and I will moderate the webinar today. But before we get into the presentation, I would like to have a quick look at how the webinar platform works. Someone may be new here and don't know how exactly the platform works. So on the right side of the screen, you will see a panel where you can type the question. We will collect all of the questions and our expert will answer the question at the end of our presentation during the Q&A session. And also, please keep in mind, we are recording today's webinar and it will be uploaded on our website in the following day. And now let's have a look at the agenda today webinar. To begin with, our IP advisor, Ms. Marta, will provide a short introduction about IPR helpdesk and our service. After that, Mr. Tuấn, Managing Partner, VCI Legal, will introduce about Vietnam new competition law, what are the changes and the impact on the foreign businesses in Vietnam. And then our external IP expert, Ms. Nga, will discuss about IP implication of Vietnam new competition law. And finally, we will have the Q&A section at the end of webinar. Now, please welcome Ms. Marta, our IP advisor. She will provide a short introduction of Southeast Asia IPR SME projects. Ms. Marta, I will turn the floor to you.
Thank you, Xuân.
Hello, Marta.
Hello. Just a second. Can you give me the floor so I can show a slide? Okay. So thank you everyone for being here. Thank you to our expert to participate in this in this webinar. Let me shortly introduce our services. We are a European project, as my colleague Xuân has explained, and we aim to provide assistance material in the topic of IP to European small and medium enterprises. What we do is offering a first line of advice, a free first line of advice to all the companies that reach out to us, but also we organize a webinar and trainings in person, like the one you are attending today. And on our website, you will find a lot of information that you can consult for free and that you can browse to better understanding the IP landscape in the entire Southeast Asia region. So not just Vietnam, that is the one we are talking about today, but also the other 9 Asian countries. So we also are welcome question after the webinar, so you can contact us on the question part of this panel, but also you can write to us and we will try to and we will answer you in 3 working days. Eventually we will contact today's speakers to address specific questions. Without any other further ado, I want to give the floor to Mr. Tuan Phung, who is the who's a lawyer here in Vietnam, and he has also a US degree. So please, everyone, welcome Mr. Tuan Phuong. Yes.
Thank you, Martha.
The floor is yours.
Okay, excellent. Thank you. So I'm showing my slide now, right? Is that so?
Yes, it's working. Yes, thank you.
Okay. So is it okay now?
Yes, it is.
All right. Okay. Well, thanks a lot, Martha, and hello everyone. It's a pleasure to me, and indeed I speak pretty often, but not to the webinar. So it's an interesting and convenient experience indeed. So I hope everybody can hear and me and see the slide conveniently. Okay.
Yeah, everything is working for the moment. Thank you.
Anything, do let me know. All right. Okay. So basically, what we're trying to walk you through today is just some key provision which are new, in comparison with the so-called old competition law in Vietnam. To tell you the truth, it is one of the law that I have the privilege of being involved since day one. Or actually even before day one, before the first draft was put together. I believe it's back then, in the 90 late 90, and then it come to, I think, 13 or 14 of different draft before the final version was adopted into law back in 2003, and it come into force in 2004. So the 2004 is the new is the old law on competition. Back then, there was still big discussion about whether or not this should be a law on competition or antitrust law in line with what is in line with the name of the law in the United States, where this law come into place the first time in the world. So anyway, it was decided back then that the law on competition would be a more appropriate, and also the model, the European model, was adopted. So it comes with more than just the regulation about competition and controlling the trust, the conglomerate on the market. It cover more than that. It cover also a certain number of competition, unfair competitive activity, and so on and so forth, as you know. Anyway, going back to the presentation today, which I'm trying to very briefly walk you through in the next few minutes. Basically, what we're trying to cover is a new issue, a new provision that we have in the new law on competition, which is 2019. Okay, and then with that, we're not trying to get into every single detail of the law itself. The law itself is a pretty big and complicated piece of legislation. So it takes days before we can really familiarize ourselves with everything in it. So instead, we're trying to focus on the differences that the new law on competition of 2018 bring along versus the 01 of 2004. And also we were going to walk briefly through a couple of impact onto the company, FDI company or company doing business in Europe as well as elsewhere in the world when the new law come into place. Because the law itself now no longer, it's only applicable for the local or domestic activity anymore. The name, the status of the game, the status of controlling competition is now going global and regional, and that is a trend that you see everywhere else in the world, not only in Vietnam. So very briefly to the theme, I'm going to skip through this quite quickly, just basically VCI Legal being a full service law firm, we are working on a number of different matters. So assisting client on corporate, M&A, competition, banking corporate, and dispute resolution, especially investment dispute resolution. We did quite a fair number of those matters recently. So practice overview, quickly to real estate, construction, petroleum, and etc. Okay, so now we, in order to make a long story short, we're gonna comparing using the very brief description of the law, say 2004, which obviously representing the old law on competition back in 2004, and 2018 being the law enacted in 2018. And the key differences that the 2018 bring along. So a couple of provision was dropped, things like and qualification was added into the law on competition, whereby you can see economic concentration is not considered anti-competitive act per se anymore, and also the concept of business or more like trade secret is made, is broadened and clarified further, and the concept of multi-level marketing was also dropped. So in terms of jurisdiction and geographical scope as well as target, there's significant change also. Back then, with 2004, you have only the law business that are doing business in Vietnam are under the impact of that law. Now, any business, any individual that are doing business related inside or outside Vietnam that have the impact onto the competitive environment in Vietnam would be subject to be adjusted by this law. And also it includes both public and related public organization. So government office are also included as one of the actors that come under the government, the scope of this law. And obviously the association, industry association are among the target. In terms of the regulation that relevant to controlling anti-competitive agreement, you can see the difference between 2004 and 2018 is that there's the old one focus on the form of the anti-competitive agreement, not the economic nature of the agreement itself or the transaction itself. 2018, they are more into detail, and they examining the substantial anti-competitive effect which caused by the agreement. It's also caused by anti-competitive agreement based on specific factors. So more on the so-called rule of law than just the per se rule. And controlling anti-competitive agreement, you can see the difference between the old and the new is the previously the only credential that the authority going to look into is the combined market share of the party, being 30% or more would subject a company into a controlling regulation. Now with 2018, then they will consider, they will review the specific criteria of the agreement, being the market share, barrier to market entry, as well as the access to essential infrastructure, in order to make a decision whether or not a certain agreement subject to be controlled, subject to be considered violation or not. So a little bit more detail. Yes, somebody was saying something?
No, it's just a technical small issue, no problem. Please continue, we were listening, thank you.
All right, okay, no problem, thanks. So horizontal agreement, there are certain conditions that put a horizontal agreement being an agreement between competitor, between company in the same industry. When agreement cause a significant anti-competitive effect onto the market, which can be considered through the some credentials such as between firms which are in the same market, directly or indirectly fixing prices, sharing customer or market or supply source, controlling the output of goods or service provided. Those are the credential worker land agreement, and act of that agreement into trouble with the law and competition. In terms of vertical agreement, being agreement between supplier and buyers and consumer or user of a good or service, then again, when it creates a negative impact on market competitiveness or causing or potentially cause significant anti-competitive effect, and such as bid witching, preventing market entry, excluding market participation, restraining investment, forcing other company into buying and selling contract of goods. So tying basically, activity are considered condition that the action which must be prohibited under the new law. So like I mentioned earlier before, economic concentration by itself is not prohibited unless it meets certain conditions set by the law. And with the new law 2018, then you have more credentials clarify in order to allow people to make a judgment whether or not a certain concentration considered prohibited. So previously you were talking about combined market share of 50% or more. Now the threshold of 50% is dropped, and then the economic concentration that create impact or likely exerting significant anti-competitive effect onto the market will be prohibited. So it's more open, it's more elusive, but more flexible in order to review. Announcement of economic concentration. Once there is previously there's a requirement for this announcement when certain market share of the enterprise is 30% or more. Now they are subject to notification threshold, which is based on total asset and turnover, transaction value, and combined market share in the relevant market in order to be considered whether or not an announcement of economic concentration is going to be made. Now, improving regulation on unfair competition. Now, this is something our college is going to get into more detail a little later, but previously, all lack of unfair competition already covered by the law. There could be that create number of conflict and overlapping area between the law of competition and the other laws, such as IP law, commercial law, advertisement law, press law, publication, pharmaceutical, insurance, etc. Now, with the new law on competition, those are dropped, and there's a specific regulation provision saying that if there is any discrepancy, if there's any conflict between the law on competition and the other specialized law, then the other law shall prevail. So it's clear that they aim to eliminate all of the overlapping. Then we come to another new regulation, which is leniency. Before there is no regulation on leniency under the old law of 2004. Now with the new law 2018, it come into place, and it's only applicable for 3 businesses that apply for leniencies and meet the condition in light of the law, and it's only applicable for maximum 5 years. In the next slide, I'm going to a little bit more condition detail of leniency, being in order to be accepted to be applied with to be exempted from applying the treatment, then you need to meet the condition. Basically, we're talking about 4 different conditions here. You only participate into the anti-competitive agreement as a party, not as a ringleader, not as an organizer. And that's number 1. And number 2, it gives you voluntarily notice the violation to the authority before a decision on investigation is made, because that shows your willingness to cooperate and to correct what was wrong, and honestly provide information and evidence in helping the authority to detect, investigate, and handle violation. Obviously, is considered a third condition for you to be applied leniencies. And the last is you are expected to fully cooperate with the authority during the investigation and handling of the violation. So as I mentioned before, if you are organizer, if you're the mastermind behind the whole grand scheme, then there's a little room for you to be able to enjoy leniency here. So if you force or arrange others to participate in the agreement, certainly that is a bad violation. So bad boy is not going to get the bonus here. Now, in terms of competition authority, as you can see here, previously the administrative body for competition called VCAD, and then there's the Competition Council. Now there's a new law enforcement agency called the National Competition Commission, whose role is to advise the Minister of MOIT for state management activity and initiate the competition proceeding, legal proceeding, control economic concentration, consider exemption for those, and handle complaint against settlement and other administrative. As you can see, also it is an areas of it's a new regulation. However, there's a lot of discussion about this. And mainly it's about whether or not a authority looking after competition issue here should be totally independent and belongs to the government itself, or it continue to be under the MOIT. And then the MOIT is obviously is one of the is a ministry that have a lot of state monopolies company. We can come to that a little later, but then after a long discussion and then the number of matters involved, it's still a commission, a state commission, national commission that's still under MOIT. Now, in terms of the trade secret definition, statutory definition, the new thing that the 2019 law that bring along is that all of the overlapping with the IP law have been removed. The new law, it's introduced the so-called secret in business. It is not fully or specifically defined yet, but then I believe it is also a legal issue, which is hard to have a very specific and very detailed and accurate definition for everyone. Now, with that being said, I hope I had covered the majority of the new regulation, new provision in the competition law. Now, on to the next part of the presentation is about the impact on the EU business in Vietnam. And very briefly, you can observe the application, the impact of this new law on competition is now going global and regional for a company that are doing business and somehow some way create impact onto the competitiveness of the market in Vietnam. And that is something you can see not only in Vietnam but also in the global regulation on antitrust matter elsewhere in the United States, in Asia, different countries in Asia, in Europe, and similar to GDPR regulation, the well-known GDPR regulation in Europe, which is applicable not only for companies in Europe but also companies that are supplying service to European season. So Now, the potential exposure and liability for foreign firm here, therefore, since the law is regional and global, now it is the two key things, the area being compliant and notification would be the two areas that foreign company or European company for that matters with business that are related to Vietnam or in Vietnam would need to pay attention of. Being if you are even you doing a entirely overseas M&A that have the potential of significantly restricting competition in Vietnam, or then you need to comply with the law here. And before a merger of that one, if you certain threshold are crossed, then you need to notify the regulator. It's a matter of M&A control. And pre-merger, therefore, pre-merger consultation with entity, board, and regulator is helpful for firms that are doing business even overseas and not directly relevant to Vietnam. Additional compliant regulation here is when you enter into horizontal and vertical agreement, then you need to ensure that you didn't cross any line, you didn't, have any suspicious conduct that can be questioned or challenged later by the authority. And compliant not only on competition law, but also IP law, law and advertising that are relevant to your transaction. Oops. So I guess I'm coming to the end of my presentation. I hope I didn't go too fast or go too slow, and but essentially that's what I believe I have on the plate today in terms of presentation. So yes, let me know if you have the question.
Many thanks for your very interesting presentation, and I'm sure the pace for us was perfect, and I'm sure it was for the attendees too. But in any case, I refer this to the attendees. If you want to ask questions, just wait until the end, and there will be a Q&A section. Or you can write to us or review the file with the recording on our website. Now we move on to the next speaker, Ms. Nha, the chairwoman of the EuroCham IPR Sector Committee. Ms. Nha, the floor is yours.
Thank you, Martha. Thank you, Mr. Tuấn, for a brief of the new changes in the new competition law. I'm the counsel of Hogan Loans based in Hanoi, Vietnam. I'm happy to share with you today the changes in the new Vietnam's new competition law and the IP implications of the changes. Today, I will talk. Sorry. Yeah. I will talk about the overlapping protections seen between the IP law and the competition law, and the first of all, the overlapping protection between the IP law and competition law. The old competition law and IP law both protect trade secrets and use and infringement of use of misleading trade indications. In the table before here, on the screen, you can see that the new competition law, as Mr. Tuấn already mentioned in his speech, no more mentions trade secrets as a subject for protection of unfair competition, again unfair competitive practices. The new competition law provides a new term, secret information in business, and if the IP law provide detailed definition of trade secret, which means information obtained from activities of financial or intellectual investment, which has not been yet disclosed and which is able to use in business. And the IP law go further to provide for conditional protection of trade secret that shall not be a common knowledge or easily obtainable, that shall create advantages for its holder, and the owner of a trade secret shall maintain necessary means to keep the secrecy of the trade secret. In the new competition law, where a new term was provided, that is the law does not provide any definition of this term and does not provide detail for conditions of protection of this new the new subject. So we hope that in very near future, the government in their guiding instruments may provide further definition and further details for this new term, or maybe the court will guide we can find guidance in the court's decisions for concrete cases later on. In addition to the protection against the secret information in business, in the law, the current IP law prohibits using marks protected in a country which is a contracting party to a treaty of which Vietnam is a member, and under which representatives and agents of owner of such marks are prohibited from using such mark if the user a representative or agents of the mark owners, and such use is neither consented by the mark owners nor justified. The IP law also prohibits registering or possessing the right to use or using domain names identical with or confusingly similar to protected trade names or marks of others, or geographical indications without having the right to use for the purpose of possessing such domain name, benefiting from or increasing the reputation and popularities of the respective mark, trade name, or geographical indications. Now, I have a short question for you to join. The question is, why does the new competition law no longer prohibit use of a misleading trade indication? Noted that use of a misleading trade indication was prohibited under the old competition law. Our options, the option for answer was A, such use no longer affects competition in Vietnam. B, such use is no longer considered an unfair competition act in Vietnam. C, this act is already provided for in the IP law. And now, please select your answer.
We are going to launch, yes, the poll screen. You have 30 seconds, 1 minute to click on your answer, the answer you think is correct, and then we will show the results and we will ask our speaker to comment. So we leave you another 5 seconds to think about the question, and now we are going to show to broadcast the results, and I will ask the expert to comment. So we see that the vast majority of the people has answered C. Ms. Nya, what do you think is the correct answer?
Yeah. So can you show the? Yes.
Yes, it says 80% of the people says this act is already provided for in the IP law, so C, and 20% of people says that such use is not an unfair competition act.
Okay, thank you for your answers. This is right. That's the majority answers were correct. The correct answer is C. This act is already for in the IP law. The new competition law has tried to avoid the overlapping protection for against use of misleading trade indications by removing these prohibition altogether from the new competition law, leaving the provisions to the IP law totally and for the IP authority to decide. Now, we go further. The competition law also has a provisions for preference of law when there is any discrepancy between the competition law and other domestic laws. Domestic laws, the old law provide preference for the competition law. That means if there is any discrepancy between the competition law, the old competition law and a domestic law, the old competition law shall prevail. In opposite, the new competition law provides for the other domestic law to prevail if there is any discrepancy of that law with the new competition law. So you can see that if there is any discrepancy between the IP law and the new competition law, irrespective of unfair competition issues, the IP law shall prevail under these provisions. For in relation to international treaties and agreements, the new and the old follow the general provisions, general principle of Vietnam law that international treaties and agreement shall prevail if there is any discrepancy with domestic law. Under the old law, under the old competition law, the rights are protected after the state, other enterprises and consumers. That means that the states, enterprises and consumers can be plaintiff in a competition proceedings. However, under the new competition law, the new competition law protects the other enterprises only. That means unfair competitive practices mean competition act performed by enterprises against the principles of good faith, honesty, business norms and standards, which cause or may cause damage to the legitimate rights and interests of other enterprises. And this is quite reasonable. The enforcement of there's a little change in enforcement authorities. Enforcement authorities under the old law is Competition Council and Competition Authority, which are both under the Ministry of Trade. Under the new law, the competition, the decisions competition decisions are made by the national competition commissions under the Ministry of Industry and Trade. The Ministry of is just a new name of the former Ministry of Trade. So in principle, there are changes in procedures, in a new competition authorities was set up, and so from the 1st of July this year, competition cases are handled by the National Competition Commissions. Under the IP law, the authorities who enforce the provisions of unfair competitions are inspectorates, the customs and market surveillance agencies. Penalties for violations of unfair competition provisions. The new and old competition laws provide similar penalties. That's the main penalties may be a warning or monetary fine. In addition, the authority can order for revocation of business or registration certificate, deprivation of licenses and practicing certificate, confiscation of infringing exhibits and facilities, confiscation of the profit earned from the violations, public rectifications, compensation for loss. Indeed, similar penalties can be found against the violations of unfair competition provisions under the IP law. That the major penalties are warning or monetary fine. That means the authorities must either warning or monetary fine. In addition, there are other measures such as confiscation of materials, evidence, and means used for the violation, suspension of professional licenses or certificates for 1 up to 3 months, suspension of production, trading, or provision of infringing products or services for up to 3 months, forcible removal of infringing element, forcible remittance of illicit earnings, etc. Regarding the monetary fine, there are a lot of changes and big change. Under the old competition law, the maximum monetary fine was around $4,400 US for individuals. Double fine, $8,500 US for violating organizations. Under the new competition law provides for 10 times increase in the maximum fines up to 2 billion Vietnamese dong. That means $88,000 US for violation by either individuals or organizations. The monetary fine for breaching unfair competition provisions under the IP law is $11 US in maximum for individuals and $22,000 for organizations. So you can see a lot of difference in the size of monetary fines between the new, but it is current competition law and the current IP laws. So you can see that now when for overlapping issues, IP law shall prevail. That means that the monetary fines apply for IP law shall be used. Now we have a second questions for you. The question is, why has the new competition law increased by 10 times the maximum fine for an unfair competitive practice act? A. Weak deterrence effect of the old penalties. B. Inflation in Vietnam. Both said answers. So please make your selection of the correct answers.
So the poll is now open. You have circa another 30 seconds to answer, and then we will comment the results. So you have another 5 seconds, and then we will show the results. Okay, we now show the results. And we see that 67% of the people have answered A, so weak deterrent effect of the old penalties, while 33% has chosen the C, so saying that both answers are correct. Ms. Niao, what do you think of these results?
Thank you for selecting your answer. I think that the A is definitely correct. Weak deterrent effects of the old penalties. With 14 years since, or 15 years since the old competition law was promulgated in 2004, the size of the monetary fine provided in the old competition law has become rather small because of the inflation in Vietnam is not too high, but there is inflation in Vietnam. Therefore, that to some extent, I think C is the correct answer. Thank you for selecting your answer. Now the question is, the new competition law already provides for a very strong administrative for enforcement of the provisions of the competition laws. So if there are some, we are talking about the National Competition Commissions as a quasi judicial authority as well. That's why we can see that under the old competition law and new competition law, court is not involved in settlement of substantive issues in violation of the competition law. We only have administrative court that can review decisions of the Competition Council under the old law and of the National Competition Commission under the new law. Civil courts can be referred to for settlement of compensation requests. There's unjustified claims, competition claims. In opposite, the IP law provides for both administrative court to review the decision of the enforcement administrative authorities and civil court for ruling on unfair competition complaints and compensation requests as well. So civil court is more involved in unfair competition issues that was initiated under the IP law. Civil remedies for cases under compensation for unjustified complaints only in both old and new law, while the civil remedies for IP law was compulsory termination of the infringing acts. That means for the violating for breaches of unfair competition acts under the IP law, compulsory public apology and rectification, compulsory performance of civil obligations, compulsory payment of damages for loss, and compulsory destruction or non-commercial distribution or use of infringing goods, raw materials and facilities. I think the time is running out. So if you have any questions, I'm happy to answer. Thank you for your attention.
Many thanks, Ms. Nya, for your very informative intervention. Now I'm going to read the question that has come through our system, but please feel free to ask more in the question section or in the sorry, or via email. First of all, a question to Mr. Tung. Since the automatic threshold of 50% of the market has been removed, how do you think the judges are going to decide when there is an economic concentration? So it's a question regarding the recent change in the competition law. Could you, Ms. Tung, please address this question?
Yes, I'm not too sure what do you mean? That the court is supposed to follow the law. So what do you mean by the court reaction?
I think the question is on what will be the elements that are going to be taken into consideration to evaluate an economic concentration now that there is no more automatic threshold. Maybe the person has not really completely understood your discussion. But if you can clarify this, it will be great.
Well, it used to be a fixed, a percentage. Now there are, it's required require the court to apply the rule of law kind of principle, more than just a fixed, simple, and arbitrary percentage of the relevant market. Given the fact that defining what is a relevant market is always a challenge, so it's hard to come up, and the lack of statistics, the lack of reliable information to define what exactly is the percentage of any particular player on the market is also a difficulty. So with this, that if somehow the participant, the court can review more the more open, more flexible condition of whether or not any particular concentration create an impact and or exerting significantly the anti-competitive effect, and that would be I guess it's not easy. I don't think it's going to be easy. It's antitrust law and competition law are not the most easy area of the law, I have to admit, to come to a conclusion on any particular action. Yeah.
Yes.
So
okay.
But they have more room to maneuver. That's what I would imagine.
Okay, thank you very much. We have a second question. This time is addressed to Ms. Nya, so the other speaker. And the question is a practical case. The competitor of the person who's making the question has stolen his domain name and used it to redirect the customer to its platform, can this person protect itself, or should it use the IP or the competition law, or both? So to make a paraphrase, what's the remedy if someone steals your IP, your domain name?
Thank you, Martha. The act of stealing a domain name, and moreover, using the domain name to get unfair advantages from the business, that shall be classified as an unfair competition act, and the sufferer may refer to the. Can you see my screen? Refer to the provisions of the IP law. I can read it aloud for you. Registering or possessing. Yes, I show it. Can you see my screen? The slides. That's one of the slides. The slides
Yes, we can. Thank you.
Registering or possessing the right to use or using domain names identical with or confusingly similar to the trade names or marks of others, or geographical indications without having the right to use for the purpose of possessing such domain name, benefiting from or prejudicing the reputation or popularity of the respective mark, trade name, or geographical indications. So, in this case, if you can refer to the IP authorities to request the authorities to take action against such unfair, that's unfair, this actually the stealing action of the competitor. Now, under the new competition law, this act cannot be taken under as an unfair competition, unfair competitive practice.
Okay, thank you for your very complete and clear answer. So with this, we have reached the end of our time for this webinar. I want to thank you again, both of our speakers, to take part of in this webinar today, and all the attendees that have participate to it with a very attentive attitude. So again, you will find everything in the upcoming days uploaded on our website. Thank you. Have a nice day.
Thank you. Goodbye, everyone. Goodbye, Martha, and our friend organizing.
Thank you. Thank you for organizing. Thank you, organizing people. Thank you, Mr. Tuấn. It was. Thank you. Bye.
Bye bye.
Sure. Looking forward to see you all soon. All right.
See you.
Cheers.